Will you state your full name, please, Ms. Carruthers?
Nissa Dolce Carrothers.
Okay. And not going into a whole lot of detail, but is Mr. Cantu stand accused of criminal charges?
Yes.
And what is he accused of?
I believe he's accused of murder and assault with a deadly weapon, and I believe some gang charge, if
Okay.
I'm not mistaken.
Okay. And we'll give Mr. Cantu a chance if he wants to as well. Uh, all right. So I'm mostly going to be asking you about the retroactive child support. So I am insisting that the retroactive child support begin September of last year, but you obviously have a right to request more than that. And if you believe that'd be best for your child, I'm with that. So uh, so when did you and Mr. Cantu separate?
It was before Jackson's birth, so I want to say in either December or January.
Okay. What month was your son born?
He was born in March.
Okay. All right. So, as I understand it, Mr. Cantu was incarcerated beginning August of 2022. So, are
Yeah.
you requesting child support between anytime between March and July of 2022?
No, I wanted starting from the date he was born, but I want the 200 taken out of it because Logan did pay the 200 to Jackson for like 2 weeks.
Okay. Well, so yeah. So you're asking the court to go back to when he was born in March. So March through July of 2022. So we're going to ask for that.
Yes.
Okay. All right, then I will as well. And then, do you have any objection to me requesting the time between September 2023 and February of 2024?
No.
And I say February 2024 because the current support obligation began in March of this year.
No, I have no objections.
Okay. Uh, so he gave you the 200.
Yes.
Um, what else has he provided? Has he ever paid a light bill? Has he ever put gas in your tank? You ever buy groceries?
He paid the 200 and then told me that that was too much for him to pay, and then he stopped paying completely. That's all he did. Before Jackson was born, he ended up buying him a car seat, but that's about it.
Okay, but that was before he was born.
Yeah.
Okay. I'll pass the witness, Your Honor.
All right, your witness, Mr. Glass.
Ma'am, do you believe that the things that Mr. Diamond has requested as far as child support are in the best interest of the child?
Yes.
And do you think that restricting dad's possession and access at the moment, or for the time being, until his criminal charges are resolved, is also in the best interest of your child?
Yes.
And it's also your understanding, is it your understanding that Mr. Cantu has some pretty restrictive uh, conditions on his bond, like he can't leave Nueces County, things like that?
Yes.
Thank you. Pass the witness.
Nothing further, Your Honor.
All right, ma'am, I'll be back to you in a moment. I'll go ahead and let the state call their next witness, please. Thank you.
Mr. Cantu, Your Honor. Sir, will you state your full name, please?
Logan Carlos Cantu.
Okay. Do you have criminal charges pending, Mr. Cantu?
Yes, sir, I do.
Okay. What charges do you have pending?
It is first degree murder, aggravated assault, and organized crime, and not affiliation.
Yes, sir.
And
I'm sorry to interrupt. Go ahead,
sorry?
sir. Please proceed. Forgive the interruption.
And yeah, and you can check with the county with whenever I was booked. I have zero gang affiliation, so the organized crime is not gang related.
Yes, sir. Do you have trial date set on those matters?
No, sir, it is pending because it is a case. My plea is self-defense on that one, but
yeah,
it's a different subject.
beg your pardon, sir. And so I don't intend to go into the details on that. You're certainly welcome to. It may not be in your best interest to go into the details on that, and the judge might want to tell you further, but I'm not requesting details, just what you were charged of.
Mr. Cantu, that's why I said earlier, we're not gonna go into details because I don't want you violating your Fifth Amendment rights and something coming up that may be used against you. Right now, again, you're only charged, you're still innocent, sir, until proven guilty. But again, I still have to deal with the charges until there's a resolution of them. But at this time, like I said, we will not go into the details of what you're charged with and the circumstances. Thank you.
Yes, sir.
Okay, and so I'll move off of this subject. So let's talk about the retroactive. So you gave her, I think it was $200. You paid over approximately $200 over. Was it Apple Pay?
Cash App, it was 206, not that the $6 makes a difference, but yeah, I did what I could when I first got out to try to show support.
And what about, do you ever pay a light bill, put gas in her tank, anything like that?
No, sir.
All right. Do you believe that retroactive support would be fair in this matter?
Can you define retroactive, if you don't mind?
So right. So what I'm asking for the court to do is I'm asking the court to calculate child support based on if you've been ordered the day that your son was born. And I'm asking the court to order you to pay what it would have been from March when he was born through July of 2022. That's 5 months. You were incarcerated most of August of 2022. So I'm not messing with August of 2022, although I think legally I could. And then I'm asking the judge to also order you to pay back what you would have had to pay had you been paying child support from September of 2023 through February of 2024. So I calculate 11 months, and if the court wants to use those numbers, and my total is $2,214, and that gives you credit. So it would be $220 by 11 months minus the 206 that you contributed. So 2,214, and however the court wants to order you to repay that. So that's what I intend to request the court. If you think that's unfair, this is your opportunity to tell the court why that's unfair.
I'm sorry, I'm thinking.
Yes, sir.
No, I don't think that it's unfair. It's just considering that it is like a lot of back payment, that I can kind of handle current payments and back payment in like a little payment plan.
So what would you ask the court to order you? How would you ask the court to order you to repay that then?
Okay, so from standard let's say this month, it's how much is it a month? 220,
well,
you said?
The 220 is the current support that's been ordered, assuming the court continues that.
Right. So
and then the interest on assuming the court uses my number, the interest would be just over $11. So 11 to keep par with the interest. A lot of times my office will ask for 50 plus the interest, but obviously the court doesn't have to follow that. The court has the discretion to do whatever he thinks is fair. So my number to the court would probably be $61. But if you think that's not reasonable, that's fair. Again, this is your opportunity to tell the court what you think would be reasonable.
I mean, keep in mind, I do pay bills and my probation fees as well. And I just, it's a lot. I don't know if you want me to go into detail about what my bills and fees are, but
it's up to you, sir. This is your opportunity to tell the court like I said, what you think is fair and why. So your choice.
Okay, so where I'm currently employed at, I make a little less than $1,000 a month, and my bills alone are just for the homestead or around $400, and then probation goes out to $75 on top of that. And not to mention basic needs and necessities.
Okay, sir, where do you work, sir?
I work for 7-Eleven.
And how many hours a week do you work?
Somewhere between, it ranges from 22 to 30, 36.
All right, and do you have a copy of your pay stub, sir?
Not at the moment. I can get those.
Okay, I would need you, and how long you been working at 7-Eleven?
I will say since somewhere around early January, mid-January this year.
All right, then, so you've been there, that's the only job you've had this year, correct?
For this year, yes.
All right, then, and you were hired as a part-time employee?
Yes, sir.
Okay. All right, then, Mr. Diamond, Mr. Glass, have y'all ever been able to see a copy of the father's pay stub?
No, Your Honor, but I'd be content to move forward with the minimum wage calculation that the court previously used.
Okay, then, well, again, under the new family code, if that's all he's making, now I'm supposed to use what his actual earnings are. But again, he could probably work at something else a little bit, get more hours, so. I'm probably looking at keeping it at the minimum wage, but I was just gonna give him an opportunity to see what we're looking at, and I'll definitely figure out what we're gonna do as far as the repayment. And let's get some information about when his trial date is, and we'll take it from there. Thank you.
Yes, Your Honor. So I'm sorry. Do you have trial dates scheduled on any of your charges, Mr. Cantu?
No, sir, I do not have a trial date.
When's the next hearing date, sir?
I'm sorry?
What's your next hearing date? You should.
What do you mean?
You do have a hearing date coming up, a pre-trial, with you and your attorney appearing before the court for setting up things?
Yes, I haven't got a date yet.
Okay. All right, thank you. You may proceed then, Mr. Diamond.
I'll pass the witness, Your Honor.
All right, Mr. Glass, you're a witness.
Mr. Cantu, you're restricted in Nueces County, is that right?
Yes, sir. I am on house arrest and I'm only allowed to go to work and home.
Okay, so you're restricted to your house and just the travel in between that and work?
Yes, sir.
Thank you. Pass the witness.
Nothing further, Your Honor.
All right, then. Any other witnesses you wish to call at this time, Mr. Diamond?
State rest, Your Honor.
All right, and you are looking at trying to make this a final today, Mr. Diamond?
Yes, please, Your Honor, unless Mr. Glass feels it needs to be something different.
All right, folks, I'm gonna go ahead and let the state make a closing statement, then the ad litem make a closing statement. And if either of you wish to make a closing statement or argument at the end of the, after they get through, I'll let you make those. But this time I'll start with the state. What's the state looking to do as far as the final law is concerned today, sir? Thank you.
Thank you, Your Honor. So would defer to Mr. Glass as far as the conservatorship as well as the possession and access, and requesting to finalize the current and child support and medical support that was ordered, asking the court to calculate retroactive support at $2,214 and asking the court to order repayment at $61 a month. And that's giving Mr. credit for the $206 that he contributed. And that's not assessing him for any of the time where he was incarcerated for the majority of the month. So yes, that's the request of the court, Your Honor.
All right, Mr. Glass.
If I could have just a moment, Your Honor, I'm sorry. Oh, wait. Yep, if I could have just a moment, Your Honor.
Not a problem, I'll pause.
Thank you. My apologies, Your Honor. I'm ready now.
All right, we're recording again, you may proceed.
Judge, I believe it's in the best interests of the child that there be no contact, possession, or access with father at this time.
All right, folks. Here's the Mr. Cantu. Here's the problem, sir. Obviously, you're not convicted of anything. You're still an innocent person, but the charges that you're charged with, sir, are very, very serious. And obviously, you're on house arrest, and you're not in Bell County, and so technically, it's your any visitation would normally, under normal circumstances, would require you to come to Bell County to exercise those visits. And and that's just not possible based on your current circumstances. So I'm probably looking at having to do certain things. So at this time, sir, I'll ask you for a closing statement of, is there anything, sir, you're asking this court to do that can fit with your current circumstances, sir?
I mean, I understand what my circumstances and charges are, but none of them are family violence related. So how does that?
Sir, it doesn't, family violence is not the only thing I can look at. I can look at any type of charge or conviction dealing with harm to a child, murder of assault, assault, murder, manslaughter, any of that stuff comes into play, sir. And obviously you got a murder charge against you. So it actually comes into play, sir. Sorry.
Yes, sir. I understand that.
And now if you're acquitted or or the charges are dropped, then obviously you can come back immediately to this court and show the court that that's no longer applicable, and I can see about making you a joint management or whatever is necessary. But again, without you having a court date for me seeing when this is going to all change, then I've got to do something to get this thing going and get support coming in while you are definitely out in the free world and at least working at a part-time amount. So is there anything else you're requesting me to do here today, sir?
I do have a question. You're saying I'm sorry, I'm not good with words. As far as the back pay and making payments, the $51 a month is to catch up on the back payments, right?
Well, I'm going to order $30 a month on those, sir, based on your current circumstances, not 51. But we'll look at doing the entire amount because that's what the law requires me to do. But instead of 51, I'm just going to go ahead and order you to pay 30. It's a little different, sir, and it probably doesn't help that much, but hopefully it helps some. The interest,
yes, and I make that
the interest on what you owe is right at $10 a month. So the 20 will take care of some principal. Yes, sir. Next question.
Okay. Is there a way that I can see like a visual of like a paper or a link to what I owe, what my payments are, or so I can keep for documentation?
You'll get a copy of the order, sir, and it'll be in the order.
Okay.
Yeah, it'll be specifically under child support and retroactive child support. It'll be spelled out, sir.
Alrighty.
And you'll be receiving a copy of that to review by DocuSign, and once it's signed off on, you will be receiving a final copy of that order, sir. Any other questions, sir?
Okay. That would be it.
All right, Ms. Carruthers, any questions or anything you'd like to add in the closing, ma'am?
Yes. So his his mother still contacts me from time to time. Is he still allowed to contact me, or within the order he's not allowed to contact me? And his mother.
Okay, here's the deal, man. First off, you don't have to take contact with mom. She's not in this case. I don't have any jurisdiction over her, and she doesn't have any rights whatsoever.
Okay.
Right now, based on his circumstances, I'm giving him very, very limited rights. I'm looking at naming you a sole management servitor. And if you do wish to, and you do wish to have contact with him, I'm going to make all contact through App Close, a parenting app. It has texting, it has FaceTime, it has all those. But based on these circumstances, until I find out what happened with this gentleman, I'm not ordering any type of contact at this point. I'm looking at naming you the sole managing conservator, giving you the right to side domicile, and until further order this court until we find out what happens. I'm looking at ordering dad to pay child support because this is his child, but I'm leaving it up to your discretion. Any and all contact you wish to have with him or have him have with the child until we know what happens with those charges down in Nueces County.
Yes, sir. I was gonna ask about the co-parenting app because my son does have behavioral issues, and they asked for his dad's background, but I wasn't able to give it to them because I couldn't contact him from last time, so that's why.
So again, ma'am, I can order the co-parenting app, but if he and he has to download it on his cell phone, and you have to download it on yours. But again, I'm not sure if that's going to help you at all as far as any third party request dealing with your son, ma'am. Again, that's not the only thing I can deal with is what's normal. Norm is for him to have visitation. Norm is for him to pay child support, but this is not a normal case. So again, I'm not giving him visitation. I'm not giving him access until he finishes whatever it happens down in New Oasis County, ma'am.
Yes, sir. That's all the questions I have.
All right, then, like I said, I'm looking at naming Mom Soul MC. She has the exclusive right to side domicile, that rights unrestricted. She is ordered. I'm ordering dad to pay child support based on minimum wage presumption guideline. I'm going to reduce the judgment, retroactive child support based on the times that he was not incarcerated. I'm going to order repayment on that amount at $30. I'm naming the dad mom managing, dad possessory, but until the court is finding it right now that based on the criminal charge, the severity of the criminal charges pending against the father in Oasis County, that under the rights of possessory conservatorship, not any such until we find out or it comes back before the court what the outcome was. Those are obviously if he comes back acquitted or dropped, then the court can go ahead and proceed to give him specific parental rights and visitation based on his circumstances. He will no longer have to be on house arrest in New Oasis County, so the court can do something about that. But for right now, I'll leave any and all access and contact with the father up to the mother. I will order that the mom get AppClose, set up an AppClose account. But obviously, if she does not want to contact dad or back through that app, then that's left up to her. Sir, you can via that app let mom know what happens with that circumstance. If you do get acquitted or the charges are dropped, then you could contact the Attorney General's office. The information will be in the order, and they can see about getting things set back up. If you get convicted, you definitely need to let the state know, sir, so we can stop the child support going forward based on that conviction and any type of jail time you do receive. So do you have any other questions, sir?
Yes, sir. Apart from my rights being restricted for now to Jackson, am I allowed to talk to the mother?
Sir, I'm not ordering her to, I gave her the right to facilitate any contact that she wishes, sir. I'm not giving you that right. No, sir. Directly, no.
Okay. That's all.
All right. Is there anything else, Mr. Glass?
No, Your Honor, nothing from the ad litem.
All right, anything else, Mr. Diamond?
Nothing further, Your Honor.
All right, again, sir, I am giving mom the right to, if she wants to, she can, but it's everything has to be through AppClose. So you do need to get your AppClose down to your cellular device and set up. And ma'am, if you do set that up, you can let him know what the information is. Again, it's left up to you. Again, I hate doing orders like this because, but I don't know what's going to happen, and until I know it, until I have something concrete, this is the best I can do. So is there anything else on your side, ma'am?
No, sir. Thank you.
All right. All right. You're both free to, both parties free to go at this time, Mr. Diamond?
Yes, Your Honor.
All right. An order will be forwarded to you by DocuSign, and we're off the record. Thank you.
Thank you, Your Honor.